All victims of institutional child abuse deserve access to justice. Institutions cannot be allowed to wash their hands of these horrendous sex crimes against children because of the contractual basis under which the perpetrator was able to commit these crimes. It's absurd that this arbitrary distinction can allow an institution to be relieved of its responsibilities for the vulnerable in its care. At the end of the day, whether a perpetrator is an employee or a volunteer, they are using that institution's authority and power to abuse a child. And we know from the findings of the Royal Commission into institutional responses to child sexual abuse that these institutions, wealthy, powerful institutions in many cases, knowingly provided refuge and in some cases even assisted evading any form of justice to serial perpetrators of child sexual abuse. It is disgusting. By removing the impediment imposed by the High Court ruling, we can ensure that a whole class of survivors of institutional child abuse are able to seek justice, and we can demonstrate again to church and other institutions that they are not above the law in this state. We cannot stand idly by. We know that the Attorney-General is meeting with other attorneys across Australia to discuss a resolution, but that is no guarantee that the laws will be reformed anytime soon. And this is a question that must be resolved swiftly. The bill is about some small measure of justice for the victims of horrendous crimes. And justice delayed is justice denied. So I draw some comfort from our discussion last night with the Attorney-General and with Mr Batchelor's comments this morning that this will be pursued vigorously and it will be pursued promptly. The survivors of institutional child abuse have waited long enough for justice. We need to afford prompt relief to the many victim survivors who have been legally gutted by the High Court's ruling. We ask for all parties' support for this bill. It is the right thing to do. I commend the bill to the Chamber.